Hi, everyone. Can everyone hear me? Cool. Thank everyone for coming. We are really excited to host you all for this screening of South Africa's case against Israel's genocide against the Palestinians. We are really excited to host this, but actually, I want to first thank the comrades who have actually put this event together. Let me know if I forgot anyone, but Leah, Nat, Habiba, Ciara, and Michael, and Felix. These comrades actually came to our volunteer meeting on Monday and gathered together after the meeting, talking through what was happening, what was going to happen today, and wanting to be in community with folks who also wanted to see the screening together and also create a space where we could discuss and build together. So I really want to thank the comrades and show that as an example. Oh, yeah, we could give them a round of applause. And I want to highlight that because our volunteer meetings are really a space for folks to come together and take action together. And we want to encourage everybody who's here today to also join us this coming Monday for another volunteer meeting. And we're going to be out in DC this Saturday. If folks haven't already bought your ticket, please do so. We're going to be mobilizing, and we're really excited to bring another 100,000 plus to the streets of DC to make sure that the politicians in DC, that Genocide Joe knows that the people of the US are not for this genocide. I want to welcome everyone to the People's Forum. Thank you again for coming. We're a space that has existed for the past 5 years, and we were created to really foster and nurture moments like this when organizations and people were ready to move, to take into action, and then also to learn and be building together. And we're really excited to continue the work and be that space for folks to take action and learn together. So we hope that this isn't your first or your last time, and we want to see you again. I'm going to pass it on to Habiba, who's going to introduce our speaker.
Thank you. It's so wonderful to see all of you here. Thank you for being here. This event was a joy to put together, and I'm so glad we were able to have this because, as we know, this is such an important and historic court proceeding, and we just wanted to have the opportunity for everyone to be able to watch it together. But also, we are so excited to have Craig Mokhiber here, who is going to help us contextualize these important proceedings, give us some background on the importance of this case. He recently stepped down as the director of the New York office, the United Nations Office for Human Rights, the High Commissioner, in response to the United Nations' lack of response in Palestine, calling it a textbook genocide. So we really commend his staunchness and are so excited to hear what he has to say regarding these proceedings. So without further ado, please welcome Craig Mokhiber. Thank you for being here.
Right. Thank you very much, Habiba. Thanks to everybody at the People's Forum. I wish I could be there in person. I wanted to visit that space, and maybe next time. I've escaped from New York recently, and so I haven't had the opportunity yet, but I will on one of my visits. And thanks for everybody for being here, and thanks to everybody for caring about what's happening today. Habiba, you used the right word, which is historic. This is an absolutely historic day, and everyone in the room who's going to be watching South Africa's presentation today to the International Court of Justice will be witnessing history in the making. This is a day that is being buzzed about, not just by international lawyers, but by people all around the world who care deeply about justice and have been deeply frustrated by the impunity that Israel has enjoyed over a period of many decades now, as it continues the persecution and dispossession of the Palestinian people, and now genocide as well. And, you know, what we saw in the presentation that you're going to see from South Africa was a truly brilliant case presentation that set out with, it seems to me, an indisputable description of the active engagement in genocide that Israel is perpetrating as we speak. And it's something very beautiful and very poetic, even in this dark moment in history, that it is South Africa that is making the presentations that you are going to see tonight. South Africa that survived and struggled and overcame apartheid, even as it was being supported by the entire Western world, including the government of the United States. That's something truly, I think, remarkable, that they are presenting this case before the International Court of Justice. It's interesting that 1948 was the year that the Genocide Convention was adopted. It was the year that the Universal Declaration of Human Rights was adopted. It was the year that apartheid was established in South Africa. And it was the year of the Nakba, the first genocidal purging of Palestinians in Palestine. And now, all of these 75 years later, because of the struggle of people all around the world, we have the survivors of apartheid in South Africa defending the Palestinian people from apartheid and genocide in Palestine. There's something beautiful about that. There's something really impressive about that. And when you see the strength of the case that's being presented here, that is in part due to the commitment of South Africa, to the brilliance of their legal team. But in some sense, I think you will see that it is a case that writes itself. You know, when the Genocide Convention was established 75 years ago, it set out a specific legal definition for genocide. And, it didn't leave it up to sort of editorial opinion, right? It said that in order for it to be genocide, you have to have the identification of a particular group based upon their ethnicity or their religion or other status. You have to have a set of specific acts like killing people, like causing extreme harm to people as a group, like creating conditions of life designed to bring about the destruction of that group, like preventing births. So these specific acts, you have to have at least one of them. In this case, South Africa has shown that Israel is committing every one of those acts against the Palestinian people. And then you have to have this other thing, because those can just be war crimes, crimes against humanity. But for it to be genocide, you have to have this specific intent to destroy the group in whole or in part as a group. In this case, the Palestinian people who are in Gaza. And mostly when you try to prove a case of genocide, what you're doing is you are digging through dusty government archives, and you're looking for secret communications between government officials where they then honestly say what it is that they are trying to do. But because Israel has enjoyed so much impunity, underwritten by the United States and by much of the Western world for so many years, they have been convinced that they will not be held accountable. And so from the very beginning of October, senior leaders in Israel have been declaring their genocidal intent publicly and on the record. And here I'm not talking about some peripheral actors here and there. I'm talking about the president, the prime minister. As the brief of South Africa shows, at least 7 ministers in the government, senior military leaders, soldiers on the ground, all openly declaring their genocidal intentions and then carrying them out on the ground as the world watches in horror, because they are convinced that they will not be held accountable. Well, what South Africa is doing in the International Court of Justice, the highest international court in the world, also known as the World Court, is that they are creating a crack, I have said, in a 75-year wall of impunity. And it is the job of all of us to force that crack open wider and wider so that the light of justice can shine through, and so that we can bring hope not just to the Palestinian people, but to people all around the world who are struggling against these kinds of atrocities. The International Court of Justice is not the International Criminal Court, right? So it's not where individuals are tried for crimes. It's a state-to-state court. And it is empowered under the Genocide Convention, the main international treaty that deals with genocide, empowers the International Court of Justice to take on these genocide cases. And South Africa has stepped up to bring Israel to the dock. And that's what you're going to be witnessing, is the arguments happening here. Now, there are two things that the court has been asked to do. One of them is to decide on Israel's commission of the crime of genocide, and then to make recommendations on what needs to be done about that. But perhaps even more importantly is that South Africa is asking for what are known as provisional measures. That's like an injunction, immediate action to be ordered by the court, because you can't wait for 2 years for the court case to be settled. But immediate action that South Africa is asking for, because they've identified a prima facie, a basic plausible case that genocide may be happening in Palestine. And that's really important because the court can rule on that in a matter of days or in a couple of weeks at the most. And what South Africa is asking for as provisional measures is that Israel be ordered to stop its attack on Gaza, to withdraw its forces, to end the siege, to allow again the food and medicine and water and sanitation and fuel and electricity and humanitarian aid and all of that to get back in to save the Palestinian people who have survived thus far, and to preserve evidence and to allow international fact-finding in, all of those things that Israel has been preventing as it carries out this genocidal assault on 2.3 million civilians who are caged, who are locked inside Gaza with no way out, who have been subjected to an absolutely brutal siege for many years now, and now who are being picked off like fish in a barrel in their tens of thousands by the Israeli genocide. So this is a remarkable case, and you will hear South Africa lay it out step by step. They will show that this is happening in a context which did not just start, in October, but that it is a part of a larger assault on the Palestinian people that has included 75 years of apartheid, of ethnic cleansing and purges, of belligerent occupation in the occupied territories, of a total siege and closure on the Gaza Strip. And how wonderful it is to see a country that has survived apartheid now coming to the defense of another people that is being subjected to apartheid. And they raise that in their petition as well. And they show clearly that the targeted group is Palestinian people in Gaza, but they say that this is connected to what's happening in the West Bank as well, where we're seeing wholesale military assaults on Palestinians in the West Bank, settler pogroms attacking Palestinians on the West Bank, the ethnic cleansing of several villages, the killing of hundreds, the imprisonment of thousands as we speak on the West Bank. And South Africa points out how that is also a part of the same case ultimately. And then they show with great clarity, with much evidence, that the acts that are prohibited in the Genocide Convention are being committed, all of them. And they then say, point by point, some of the horrific genocidal statements of intent coming from the Israeli leadership that leaves no doubt that this is not about a war against Hamas. This is not about releasing hostages. If it was about releasing hostages, you wouldn't drop bombs on where they're living. But this is, in fact, a wholesale ethnic purge of the Gaza Strip and a commission of the crime of genocide. So if as we expect to prevail in this case, South Africa gets the court to rule on these provisional measures to be implemented, we can fully expect that Israel will probably refuse to implement them, some or all of them, and that the case will then go to the Security Council in the UN. The United States will almost certainly then veto to prevent Israel from being forced to implement the decision of the court. It will then move into the General Assembly of the United Nations that will be able, because the majority of countries in the world will agree to adopt measures to try to force Israel to act. And it will also go to the courts of any country. Genocide is known as a crime of universal jurisdiction. It means that it can be enforced in any court anywhere, but it will also fall on all of us. Because what's going to make the difference in this case of genocide and the broader struggle for justice, the struggle against apartheid, the struggle for Palestinian liberation, struggle for human rights all around the globe is what people, movements, civil society, all of us do to demand accountability for perpetrators and redress for victims and justice in this case, and respect for international law that's being so blatantly violated here. And that's going to happen through things like boycott and divestment and sanctions, demonstrations in the streets, mobilizations like we have never had before that are helping already to make a difference. So this is a bright moment in what has been a very, very dark period in our history, and we owe a lot to South Africa for bringing this case. I'll probably stop there, and I'm happy to take any questions if that's helpful, or we can just roll the stream if that's preferred.
Sure, we can. Is this on? If anyone has any questions they'd like to ask, I can come up and handle them. Sure.
Do you expect the court to grant all of the provisional measures that South Africa has requested, or some of them more likely than others?
Yeah, I fully expect that they will grant the provisional measures, because the standard for granting the provisional measures is lower than the ultimate case. It's just, as I say, kind of a plausibility standard. So I think they will grant provisional measures. And I think the provisional measures that have been included there, when you look at previous cases of this sort, are consistent, entirely reasonable, and I would even argue necessary. So yes, I would expect that they would insist on an end to the attacks and the hostility, withdrawal of forces, and allowing in international aid and turning back on the electricity and the water and all of that. But again, the challenge would be getting Israel to do that after 75 years of impunity. But I'm hopeful there are things that can be done on that front as well.
Habiba, grab the next one.
Hi, just first wanted to say thank you so much for your actions at the UN. That was really inspiring for all of us. Thank you so much for doing that and for being here. I was wondering, do you have thoughts on which countries will vote which way? Do you think we'll get the 8 we need? Do you think we'll get more? Do you think we'll get less?
Yeah, I think so. In this first decision-making process on the provisional measures, I think there will be a majority of judges, and I think that they will be granted. It would be quite extraordinary. It would take some remarkable judicial gymnastics in this case for the judges not to determine that provisional measures are warranted. So I think we will succeed there. Now, you're right to ask about the judges. The president of the International Court of Justice at the moment is an American judge who has spent her entire career inside the State Department, working as a lawyer, defending the U.S., even in periods where the U.S. was involved in complicity with violations against the human rights of the Palestinians, right? So that's not an ideal situation. And there are other judges who come from, because they are independent judges, right? And they take an oath and they're supposed to be impartial and so on, and they're not representing their countries. But we know that judges are human beings. We know that they come with their politics and their biases. And we know that that does affect decision-making in every court in the world. And this court is no different in that regard. However, I think that the court, and I should say about that American judge, she's only in that chair until the 5th of February because her term is ending. And on the 5th of February, she will not only step down as president, but she will leave the court and she will be replaced by another American judge whose background still close to the American policy establishment, but she comes from a kind of human rights organization background. So a better profile in general. And she will not be president. A new president will be elected. So I hope I got a little off track there. So where was I going with this? Yeah. So the judges have their biases like all judges, but they are also constrained. They're constrained by the precedent of the court. This is a court that has ruled on Israel before. 20 years ago, they ruled on the illegality of the apartheid wall on the West Bank. And they made a lot of decisions in that regard. For example, they ruled that Israel cannot claim self-defense for its activities in the occupied territories under Article 51 of the Charter, because they are the occupying power, and that will not give them the right to go to war or to take extreme measures against Palestinians because they're the occupying power. So some of this has been decided by this court, and they've decided on genocide cases where they've had a much lower standard than what's being presented here. So they couldn't simply just ignore that and move on very easily. They're also very much aware that the eyes of the world are on this case, and that they will be very limited on the merits in not supporting what is before them. I would also say that the defense that's likely to come from Israel, I'm happy to talk about that, is going to be very weak in legal terms. Right? And I think that what Israel will be presenting will be a case which is designed to try to affect public opinion in the West more than it is designed to affect the decisions of the judges, because the case against them is so overwhelmingly damning. But the judges won't be able to throw it that way. Now, there's a weird thing on the International Court of Justice, which is that each of the parties to a dispute is able to actually add a judge. They're called ad hoc judges for purposes of this case. So they're also adding an Israeli judge, and they're adding a South African judge. The Israeli judge is no friend of human rights and no friend of the Palestinian people. He is a jurist who has consistently ruled in favor of gross violations of human rights committed against Palestinians in the occupied territories, and who has, basically helped to codify racial discrimination in law. And just very recently, in November, he was quoted in an interview saying, "I totally agree with what the government of Israel is doing. It may be proportional to kill 5 innocent children in order to target their leader." But he's now been appointed by Israel as their ad hoc judge in the court. Now, we can't worry too much about that, because the South African judge will balance that off numerically, right? They'll sort of cancel each other out. But you can create difficulties in the deliberations, and so we have to factor that in with regard to the judges as well. But overall, I don't think you can go through the judges, look at the country that they came from, and decide on that basis how they're going to vote. That has not been the case in the past. Sometimes you get reflections of that. You have a very conservative judge from France, who in the past has shown, for example, a previous decision with regard to Israel, he raised a political objection, which you don't hear from judges, something to the effect that, no, we should not take this case on because it's not helpful to the political process. Well, that's not the role of a judge, and it showed bias in my view. But I think overall, the weight of the case, the weight of the evidence, the jurisprudence of the court that binds them, the language of the Genocide Convention that binds them, and the knowledge that the eyes of the world are on this case will prevent them from going particularly rogue. And I think that the case and justice will prevail, even over the objections of some of the judges. But you never know until it's over. I should say, just in case you quote me when it all falls apart, the United States and others in the West have mobilized very significant resources, as have the Israelis, to bring a pressure campaign to bear on other states, first, not to support South Africa's petition in the court, and secondly, to try to obstruct it politically. And, anything is possible. At some point, they may prevail. They have a lot of ways to influence, through fear or favor, through carrots and sticks, through pressure and bribes. So anything is possible. But if you ask me today, and having read the case and having followed this situation for a long time, I would say that this is not winnable for Israel.
We'll take this lady's question, since the gentleman in front ceded his place in line. So,
I'm kind of curious. Obviously, the ICJ is very symbolic, in the sense that it has very limited resources and power to actually carry out the sentence, were they to convict anyone or any state. So, in your opinion, what would be the realistic outcome were Israel to be convicted by the court, to be found guilty of genocide, both procedurally as well as, I guess, in a public sense, symbolic sense?
Well, you're right that the symbolism is extremely important here. A finding of genocide by the World Court against a state is an enormously powerful legal statement, but it's also a very powerful political statement, right? This is not a debate between, pro-Israel and pro-Palestine people. This is a legal finding in the highest court that Israel is engaged in genocide. And as I said, the case is not only looking at the genocide, although that's the legal issue to be decided, but it's setting out a context of apartheid and persecution and ethnic cleansing and so on over 75 years. And that would be very important, I think, politically. Of course, the U.S. will do everything that it can to make sure that it remains only symbolic. They will block enforcement in any way that they can. As I said before, if Israel refuses to implement the decisions of the court, then it goes to the Security Council for enforcement. There, the U.S. will veto anything. They will continue to protect Israeli impunity. It'll go to the General Assembly. The Assembly can adopt measures, and individual states everywhere can adopt measures, individually or collectively. Arrest warrants could be issued in court cases in individual states that would make it very hard for some of the perpetrators to travel for fear of being arrested on these indictments. And remember that countries have extradition treaties between them, so it's not just the countries that issue an indictment or arrest warrant, but it's some of the countries that participate with them. And so Netanyahu will have to think very carefully about where he travels in this case. And I should say, just another legal point is that a finding of genocide by this court is going to impose obligations on all countries, because all countries, first, all the parties to the Genocide Convention, which is 156 countries, something like that, most of the countries in the world, they are obliged to give effect to this decision as well. They're obliged to punish genocide, to prevent genocide, and to not be complicit in genocide, and then to cooperate with what the court will decide. So they will have to take measures. Some of them won't, but that obligation exists, and people can press countries to take those measures based on that decision. The other thing that could happen is, as I hinted before, is it could become the basis for sanctions, for boycotts, for divestment, for public mobilizations, for withdrawal of consular relations, for withdrawal of recognition of passports, for withdrawal of diplomatic missions, for the ending of trade agreements, for suspension from international organizations, until the offending state is brought into compliance with what the court has ordered. So this is very powerful. We have another problem. I don't know if I mentioned this, but the prosecutor of the International Criminal Court, which is a separate court, is thoroughly politically corrupted and biased. And he has dragged his feet to avoid acting on cases brought before him by Palestine for years now. And he has refused to act on that, and so far refused to act on the genocide happening in Gaza. To the contrary, he traveled to Israel to meet with Israelis and refused to go to Gaza. And he has been obstructing these cases in the International Criminal Court. But the pressure, if there's a finding here, that will increase the pressure on the International Criminal Court. And the truth is, the International Criminal Court, which has focused, almost all of his energy on prosecuting people of the South while exempting the West, is losing its credibility more and more every day. And its legitimacy is hanging by a thread. And this case could be either the end of the legitimacy of the International Criminal Court in the eyes of most of the world, or an opportunity for the International Criminal Court to save itself by acting on it. And they will be pushed by a finding of the International Court of Justice to not be able to ignore these cases going forward. And then in addition, the Center for Constitutional Rights in the US has brought a case against officials in the Biden administration for complicity in genocide. Complicity in genocide is a separate crime under the Genocide Convention, and US support for Israel while it's committing genocide by providing weapons and military support and economic support and intelligence support and diplomatic support, using its veto, using the podiums of the State Department, the National Security Council, the Pentagon, the White House, to disseminate Israeli propaganda and justifications for war crimes. All of that adds up to legal complicity for which they can be held accountable, and a decision in the International Court of Justice will strengthen those cases. So what happens here is not automatically going to be enforced, and there will be opposition to its enforcement by powerful states like the US and the UK. But nevertheless, there is power in this, and if we all continue to raise our voices, we'll make it impossible for them to ignore what the court decides in this case.
I have time for one more question, and we've got the... Which of you two? All right. Make it a good one.
Well, good evening, Siam Lake, because today I just came from protest for closing regional to. So what happened was in 9/11. I'm not the Palestinian person. I'm a Palestinian supporter, because what happened was what happened in since October 7th, and now we're sitting here on 100 days since what happened in Gaza were being bombed by Israel. So the thing is that we have to stop this. We have to stop this genocide or the Zion, because the Zionism must go. That's all I have to say.
Can I ask my question? Okay. Hi, Craig. First, I just wanted to thank you for so clearly and concisely providing these answers for us, especially for us that are not familiar with international law. My question for you is maybe a bit more speculative, and I'm really curious about Russia and China's maybe calculus in this for the short-term provisions or the long-term court case. They've, of course, been accused of genocide in Ukraine and the Uyghurs in China. And I'm curious, would that make them more reluctant to maybe vote in favor of South Africa's accusations today, in fear of maybe opening up a can of worms upon themselves?
So what you're asking me about is the judges, right? So again, they're not directly representing Russia and China. There is a Chinese judge and there is a Russian judge on the court. But it's not like the Security Council or the General Assembly, where they're going to directly take their state positions. Again, they will behave as judges in factoring these things in. They will have certain biases. That's for sure. They may individually factor in national political considerations. There's no way for me to know that for sure. But on balance, on balance, I think the numbers will be okay. Again, you never know until it's over, and there are others out there who I respect who are predicting the opposite, who are simply sort of adding up the nationalities and saying, well, the numbers don't add up. And again, we're going to be dealing with two panels of judges, depending on whether you're talking about these provisional measures in the first bite or in the case on the merits coming later, because that switch happens in February. But I don't know quite how to answer. I would say it will be a factor for those judges, just as national considerations are factors for some of the other judges. I don't know if it will be determinative. We'll have to wait and see the position that they take. There's also the possibility, because these are judicial proceedings, that they can agree with the decision overall but dissent on a particular piece, or they can issue a separate decision where they go along with the majority, but they do it from a different spin because they're trying to protect certain interests. So that's often done in these court cases. That might happen with those particular judges. We'll just have to wait and see. Yeah.
Thank you so much, Craig, for being here and for answering all of these questions, giving us this information so concisely, and for clarifying everything. Can we get a round of applause, please, for everyone?
Thank you very much. Thanks for caring. Thanks for coming together. And I think you're going to be moved by what you are about to see. I certainly was early this morning when I was watching the proceedings. It's very powerful and compelling stuff. So thanks for everything that you do, and I hope to meet you all in person someday.
Thank you. So on that note, we'll be moving on to watching the screening, which I'm sure we're all very excited to get to. Nathaniel's going to come up and give us a little introduction about the structure of what we're about to see briefly, and then we'll welcome everyone to the snacks we have over there, and we can all get comfortable and start watching. Thanks.
How's it going, y'all? Nice to see you again. But purely for my own mollification, I'm curious, how did you all find out about this event? Can you get like a show of hands, like who was following the People's Forum Instagram account? All right, so the bulk of people is following some other Instagram account that said this, or the website, right? Twitter? Okay, good to know. So I won't take up too much of your time. As far as I'm nobody important, I promise you, but I did also, I care a lot about this, and I saw the proceedings earlier today. We sort of got together to organize this screening because we figured that it would be of a lot of educational value to people. We figured that it would be a notable moment. It would be something that people would be interested in coming to see. And we were, hopeful that South Africa would make a good case at the UN or at the ICJ. And when I watched the court case this morning, I think what we ended up with was what I would argue is going to end up being one of the most important historical documents of the 21st century. I'm not exaggerating when I say that. So it is truly historical. It is an incredibly researched case. And it's also 3 hours long. So I know that people here, given that it's already a little late, I know people have time constraints, so I'll give you a little bit of a guide to what the structure of everything is. South Africa will start with some preliminary remarks, and they'll start with an introduction to the case. And then there will be 6 speakers total who will each present a different aspect of the case. The first 2 speakers are Adila Hassim and I'm forgetting the name, but Adila Hassim is talking about the current acts of genocide that Israel is committing, and then Tembeka Ngukai Toby is talking about the genocidal intent. If you cannot stay for anything else, stay for those 2 speakers. Those to me are the most important parts of the entire case. The third speaker is it's John Dugard. It's John Dugard, who's I believe a professor who has a lot of experience dealing with the ICJ. He's talking about jurisdiction, and his section is one that we will probably skip. No disrespect meant to John Dugard, but again, I know we have time constraints, and I think his section is just the most abstract and the most legalese. I highly recommend you go back and watch it on your own free time. So we'll probably skip to the fourth speaker, Max Duplessis, who will talk about the rights that they're attempting, the rights that are under threat, and the rights that South Africa is petitioning to protect in Palestine. And then the 5th speaker, another name, I'm terrible with names. Was it the Irish? Blinini Grale. Also, if you can stay for that long, please stay for her speech. It's incredible. She will be talking about the immediate need for interventions. And the final speaker will be talking about basically what are the actual interventions what are the actual provisionary measures that South Africa is asking for. So that's kind of the layout. I hope you all enjoy. Oh yeah, get the snacks. They're there for you. I'm not going to eat them all myself. And why don't we, since people are getting up, go get the snacks, and then we'll get everything, we'll get things started.
Second,
Starting the video, but just
together
it's
with
the
forced
first chunk is
displacement,
just the judges swearing oaths and
Israel's
stuff.
conduct
You
has been
don't have to watch too
deliberately
closely.
calculated to cause widespread hunger, dehydration, and starvation. Israel's campaign has pushed Gazans to the brink of famine. An unprecedented 93% of the population in Gaza is facing crisis levels of hunger. Of all
If anyone would like some water, you can go outside this door, take a left, and you should be able to see a water fountain with some cups. Out this door to the left. Just kidding. Okay, it's empty. Sorry, one sec. Just give us one moment and we'll try to figure out a water situation for everyone.
Please be seated. Sitting is open. The court meets today and will meet tomorrow under Article 74, Paragraph 3 of the Rules of Court to hear the oral observations of the parties on the request for the indication of provisional measures submitted by the Republic of South Africa in the case concerning application of the Convention on the Prevention and Punishment of the Crime of Genocide in the Gaza Strip, South Africa versus Israel. The court does not include upon the bench a judge of the nationality of either party. Accordingly, both parties avail themselves of the right under Article 31, Paragraph 3 of the statute to choose a judge ad hoc. South Africa has chosen Judge Dikgang Ernest Moseneke and Israel, Judge Aharon Barak. Article 20 of the statute provides that every member of the court shall, before taking up his duties, make a solemn declaration in open court that he will exercise his powers impartially and conscientiously. Pursuant to Article 31, paragraph 6 of the statute, that same provision applies to judges ad hoc. Before inviting Judge Moseneke and Judge Barak
The water
to
has
make
been
their solemn
refilled. If anyone
declarations,
wants to
I
go
shall
get water,
first,
go ahead.
in accordance with custom, say a few words about their careers and qualifications. Judge Dick Gang Ernest Moseneke, of South African nationality, has had a distinguished career as a judge, law practitioner, and academic. After obtaining degrees in English, political science, and law from the University of South Africa, he practiced as an attorney and an advocate with the Pretoria Bar. In 2001, he was appointed a judge on the High Court in Pretoria, and a year later, he became a judge on the Constitutional Court of South Africa, where he was Deputy Chief Justice for more than a decade and Acting Chief Justice in 2013 and 2014. Judge Moseneke is also an honorary professor in the Department of Jurisprudence at the University of Pretoria and has served as a Chancellor of the Pretoria Technikon and the University of Witwatersrand in Johannesburg. Judge Moseneke has received numerous honorary doctorates and awards. I shall now say a few words about the career and qualifications of Judge Barak. Judge Aharon Barak, of Israeli nationality, has had an eminent career as a judge and law professor. He holds a PhD in law from the Hebrew University of Jerusalem and served as the Dean of the Faculty of Law of that university between 1974 and 1975. He was appointed to the Israeli Supreme Court in 1978 and served as its president from 1995 to 2006. Prior to joining the Supreme Court, Judge Barak served as the Attorney General of the State of Israel between 1975 and 1978. He has taught law in a number of law schools, including Yale University, the Hebrew University of Jerusalem, and the Reichman University in Herzliya, Israel. Judge Barak has also written extensively in law and has received numerous honorary degrees and awards. In accordance with the order of precedence fixed by Article 7, Paragraph 3 of the Rules of Court, I shall first invite Judge Moseneke to make the solemn declaration prescribed by the statute, and I request all those present to rise. Judge Moseneke, you have the floor.
I solemnly declare that I will perform my duties and exercise my powers as a judge honorably, faithfully, impartially, and conscientiously.
I thank Judge Moseneke, and I now invite Judge Barak to make the solemn declaration prescribed by the statute. Judge Barak, you have the floor.
I solemnly declare that I will perform my duties and exercise my powers as judge honorably, faithfully, impartially, and consciously.
I thank you, Judge Barak. Please be seated. I take note of the solemn declarations made by Judge Ad hoc Moseneke and Judge Ad hoc Barak, and I declare them duly installed as judges ad hoc in the case concerning application of the Convention on the Prevention and Punishment of the Crime of Genocide in the Gaza Strip, South Africa versus Israel. I shall now recall the principal steps of the procedure in the present case. On 29 December 2023, the government of South Africa filed in the registry of the court an application instituting proceedings against the State of Israel, alleging violations by the latter of its obligations under the 1948 Convention on the Prevention and Punishment of the Crime of Genocide. I shall refer to this convention as the Genocide Convention. To found the jurisdiction of the court, South Africa invokes Article 36, Paragraph 1 of the Statute of Court and Article 9 of the Genocide Convention. South Africa states that its applications concerns acts threatened, adopted, condoned, taken, and being taken by the government and military of Israel against the Palestinian people, a distinct national, racial, and ethnical group, in the wake of the attacks in Israel on 7 October 2023. South Africa contends that the acts and omissions by Israel of which it complains are genocidal in character because, I quote, they are intended to bring about the destruction of a substantial part of the Palestinian national, racial, and ethnical group, that being the part of the Palestinian group in the Gaza Strip, end of quote. South Africa asserts that the relevant acts are attributable to Israel, which has failed to prevent genocide and is committing genocide, and which has also violated and continues to violate other fundamental obligations under the Genocide Convention. The application contains a request for the indication of provisional measures pursuant to Article 41 of the Statute of Court and Articles 73, 74, and 75 of the Rules of Court. According to South Africa, I quote, provisional measures are necessary in this case to protect against further severe and irreparable harm to the rights of the Palestinian people under the Genocide Convention, which continued to be violated with impunity. South Africa requests that the court indicate provisional measures to protect and preserve those rights, as well as its own rights under the Convention, and to prevent any aggravation or extension of the dispute pending the determination of the merits of the issues raised by the application. End of quote. The registrar will now read out the passage from the request specifying the provisional measures which the government of South Africa is asking the court to indicate. You have the floor, Mr. Registrar.
Thank you, Madam President. I quote, 1. The State of Israel shall immediately suspend its military operations in and against Gaza. 2. The State of Israel shall ensure that any military or irregular armed units which may be directed, supported, or influenced by it, as well as any organizations and persons which may be subject to its control, direction, or influence, take no steps in furtherance of the military operation referred to point 1 above. 3. The Republic of South Africa and the State of Israel shall each, in accordance with their obligations under the Convention on the Prevention and Punishment of the Crime of Genocide in relation to the Palestinian people, take all reasonable measures within their power to prevent genocide. 4. The State of Israel shall, in accordance with its obligations under the Convention on the Prevention and Punishment of the Crime of Genocide, in relation to the Palestinian people as a group protected by the Convention on the Prevention and Punishment of the Crime of Genocide, desist from the commission of any and all acts within the scope of Article 2 of the Convention, in particular, a. Killing members of the group, b. Causing serious bodily or mental harm to the members of the group, c. Deliberately inflicting on the group conditions of life calculated to bring about its physical destruction in whole or in part, and d. Imposing measures intended to prevent births within the group. 5. The State of Israel shall, pursuant to point 4c above, in relation to Palestinians, desist from and take all measures within its power, including the rescinding of relevant orders, of restrictions and/or of prohibitions to prevent a. The expulsion and forced displacement from their homes, b. The deprivation of b1. Access to adequate food and water, b2. Access to humanitarian assistance, including access to adequate fuel, shelter, clothes, hygiene, and sanitation. B3, medical supplies and assistance. And C, the destruction of Palestinian life in Gaza. 6. The State of Israel shall, in relations to Palestinians, ensure that its military, as well as any irregular armed units or individuals which may be directed, supported, or otherwise influenced by it, and any organizations and persons which may be subject to its control, direction, or influence, do not commit any acts described in 4 and 5 above, or engage in direct and public incitement to commit genocide, conspiracy to commit genocide, attempt to commit genocide, or complicity in genocide. and insofar as they do engage therein, that steps are taken towards their punishment pursuant to Articles 1, 2, 3, and 4 of the Convention on the Prevention and Punishment of the Crime of Genocide. 7. The State of Israel shall take effective measures to prevent the destruction and ensure the preservation of evidence related to allegations of acts within the scope of Article 2 of the Convention on the Prevention and Punishment of the Crime of Genocide. To that end, the State of Israel shall not act to deny or otherwise to restrict access by fact-finding missions, international mandates and other bodies to Gaza to assist in ensuring the preservation and retention of said evidence. 8. The State of Israel shall submit a report to the court on all measures taken to give effect to this order within 1 week, as from the date of this order, and thereafter at such regular intervals as the court shall order, until a final decision on the case is rendered by the court. 9. The State of Israel shall refrain from any action and shall ensure that no action is taken which might aggravate or extend the dispute before the court or make it more difficult to resolve. End of quote.
I thank the Registrar. Immediately after the application containing the request for the indication of provisional measures was filed, the Deputy Registrar transmitted an original copy thereof to the Government of Israel. He also notified the Secretary General of the United Nations. According to Article 74, Paragraph 1 of the Rules of Court, a request for the indication of provisional measures shall have priority over all other cases. Paragraph 2 of the same article states that the court shall proceed to a decision on the request as a matter of urgency. This imperative must, however, be balanced with the need to fix a date of oral proceedings in such a way as to afford the parties an opportunity to be represented at the hearings. Consequently, the parties were informed that the date for the opening of the oral proceedings, during which they could present their observations on the request for the indication of provisional measures, had been fixed for Thursday, 11 January 2024, at 10 a.m. I would now like to welcome the delegations of South Africa and Israel, and I note the presence before the court of the agents and counsel of both parties. This morning, the court will hear the single round of oral argument of South Africa, which has submitted the request for the indication of provisional measures. It will hear Israel tomorrow morning at 10 a.m. For purposes of this single round of oral argument, each party will have available to it a 3-hour sitting. In this first sitting, South Africa may, if required, avail itself of a short extension beyond 1 p.m. today in view of the time taken up by these introductory remarks. Before I give the floor to the agent of South Africa, I wish to draw the party's attention to Practice Direction 11, which states as follows, I quote, "In oral proceedings on the request for the indication of provisional measures, parties should limit themselves to what is relevant to the criteria for the indication of provisional measures as stipulated in the statute, rules, and jurisprudence of the court. They should not enter into the merits of the case beyond what is strictly necessary for that purpose." End of quote. I now give the floor to the agent of South Africa, His Excellency Mr. Visumuzi Madonsela. You have the floor, Excellency.
Madam President, distinguished members of the court, it is an honor and a privilege for me to appear before you today on behalf of the Republic of South Africa. I wish to express my gratitude to the court for convening this hearing on the earliest possible date to entertain South Africa's request for the indication of provisional measures in this matter. In our application, South Africa has recognized the ongoing Nakba of the Palestinian people through Israel's colonization since 1948, which has systematically and forcibly dispossessed, displaced, and fragmented the Palestinian people, deliberately denying them their internationally recognized inalienable right to self-determination and their internationally recognized right of return as refugees to their towns and villages in what is now the State of Israel. We are also particularly mindful of Israel's institutionalized regime of discriminatory laws, policies and practices designed and maintained to establish domination, subjecting the Palestinian people to apartheid on both sides of the Green Line. Decades-long impunity for widespread and systematic human rights violations has emboldened Israel in its recurrence and intensification of international crimes in Palestine. At the outset, South Africa acknowledges that the genocidal acts and omissions by the State of Israel inevitably form part of a continuum of illegal acts perpetrated against the Palestinian people since 1948. The application places Israel's genocidal acts and omissions within the broader context of Israel's 75-year apartheid, 56-year occupation, and 16-year siege imposed on the Gaza Strip, a siege which itself has been described by the director of UNRWA Affairs in Gaza as a silent killer of people. As the Committee on the Elimination of Racial Discrimination warned on December 21st, hate speech and dehumanizing discourse targeted at Palestinians is raising severe concerns regarding Israel and other states' parties' obligation to prevent crimes against humanity and genocide in the Gaza Strip. This warning has been followed by a succession of warnings, including by 37 United Nations special rapporteurs, of the failure of the international system to mobilize to prevent genocide in Gaza. Today, we are joined in court by representatives of the Palestinian state, the Palestinians who work in the fields of human rights, including residents of Gaza who were in Gaza just a few days ago. They are some of the lucky ones who managed to get out of Gaza. Their future and the future of their fellow Palestinians who are still in Gaza depend on the decision this court will make on this matter. With the leave of the court, I now call upon His Excellency Mr. Ronald Lamola, Minister of Justice of the Republic of South Africa, to make South Africa's substantive opening remarks.
I thank the agent of South Africa for his statement, and I now invite the Minister of Justice and Correctional Services for the Republic of South Africa, His Excellency Mr. Ronald Lamola, to take the floor. You have the floor, Excellency.
Thank you, Madam President, and distinguished members of the court. It is an honor for me to stand here in front of you on behalf of the Republic of South Africa on this exceptional case. In extending our hands across the miles to the people of Palestine, we do so in full knowledge that we are part of a humanity that is at one. These were the words of our founding president, Nelson Mandela. This is the spirit in which South Africa acceded to the Convention on the Prevention and Punishment of Crime of Genocide in 1998. This is the spirit in which we approach this court as a contracting party to the Convention. This is a commitment we owe to the people of Palestine and Israelis alike. As previously mentioned, the violence and the destruction in Palestine and Israel did not begin on the 7th of October 2023. The Palestinians have experienced systematic oppression and violence for the last 76 years. On 6 October 2023 and every day since October the 7th, 2023. In the Gaza Strip, at least since 2004, Israel continues to exercise control over the airspace, territorial waters, land crossing, water, electricity, and civilian infrastructure, as well as over key government functions. Entry and exit by air and sea to Gaza is strictly prohibited, with Israel operating the only two crossing points. Given that continuing effective control by Israel and over the territory of Gaza, Israel is still considered by international community to be under belligerent occupation by Israel. South Africa unequivocally condemned the targeting of civilians by Hamas
and other Palestinian armed groups and the taking of hostages on the 7th of October 2023, and has again expressly recorded this condemnation, mostly recently in its note verbal to Israel on the 21st of December 2023. That said, no armed attack on a state territory, no matter how serious, even an attack involving atrocity crimes, can provide any justification for or defense to breaches to the Convention, whether as a matter of law or morality. Israel's response to the 7th of October 2023 attack has crossed this line and give rise to the breaches of the Convention. Faced with such evidence and our duty to do what we can do to prevent genocide, as contained in Article 1 of the Convention, the South African government initiated this case. South Africa welcomes the fact that Israel has engaged with the case in order to have the matter resolved by the court, after careful and objective consideration of the facts and submission put before it, as the parties to the Convention have intended. This hearing is concerned with South Africa's request to the court for the indication of provisional measures and will necessarily have a narrow and particular focus. I invoke the words of Martin Luther King when he said, "The arch of the moral of the universe is long, always bending towards justice." South Africa's case will be presented by a team of 6 legal counsels, comprising of Dr. Adila Hasim, Mr. Tembeka Ngcukaitobi, Professor John Dugat, Ms. Blim Licron, Mr. Max Dupris, and Professor Vagan Low. Dr. Adila Hasim, Senior Counsel, will provide an overview of the risk of genocidal acts in the perpetual vulnerability to acts of genocide. Mr. Tembeka Ngcukaitobi, Senior Counsel, will examine Israel's alleged genocidal intent. Professor John Dugat, Senior Counsel, will focus on the prima facie jurisdiction. Professor Max Duplessis, Senior Counsel, will discuss the various rights currently under threat. Blini Crowell, King's Counsel, will present the argument of agency and potential irreparable harm. And Professor Vagan Low, King's Counsel, will speak on the provisional measures. I now request, Madam President, the court to call on Dr. Hasim. I thank you.
His Excellency, Mr. Lamola, and I now invite Ms. Adila Hasim to address the court. You have the floor, Madam.
Thank you. Madam President, distinguished members of the court, it is a privilege to appear on behalf of the Republic of South Africa in this case of exceptional importance. It's a case that underscores the very essence of our shared humanity as expressed in the preamble to the Genocide Convention. It's my task to address the court on the genocidal acts that have led to this urgent request for provisional measures under Article 41 of the Statute of the Court. South Africa contends that Israel has transgressed Article 2 of the Convention by committing actions that fall within the definition of genocide. The actions show a systematic pattern of conduct from which genocide can be inferred. Allow me to place these acts in context. Gaza is one of the 2 constituent territories of the occupied Palestinian territories, occupied by Israel since 1967. It is a narrow strip of approximately 365 square kilometers, as depicted in the map now displayed. Israel continues to exercise control over the space territorial waters, land crossings, water, electricity, electromagnetic sphere, and civilian infrastructure in Gaza, as well as over key governmental functions. As the Honourable Minister has said, entry and exit by air and sea to Gaza is prohibited, with Israel operating the only two crossing points. Gaza, which is one of the most densely populated places in the world, is home to approximately 2.3 million Palestinians, almost half of them children. For the past 96 days, Israel has subjected Gaza to what has been described as one of the heaviest conventional bombing campaigns in the history of modern warfare. Palestinians in Gaza are being killed by Israeli weaponry and bombs from air, land, and sea. They are also at immediate risk of death by starvation, dehydration, and disease as a result of the ongoing siege by Israel, the destruction of Palestinian towns, the insufficient aid being allowed through to the Palestinian population, and the impossibility of distributing this limited aid while bombs fall. This conduct renders essentials to life unobtainable. At this provisional measures stage, as this court has made clear in the Gambia-Myanmar case, it is not necessary for the court to come to a final view on the question of whether Israel's conduct constitutes genocide. It is necessary to establish only whether at least some of the acts alleged are capable of falling within the provisions of the Convention. On analyzing the specific and ongoing genocidal acts complained of, it is clear that at least some, if not all of these acts, fall within the Convention's provisions. These acts are documented in detail in South Africa's application and confirmed by reliable, often UN sources. It's thus unnecessary and impossible for me to recount all of them. I will highlight only some in order to illustrate the pattern of genocidal conduct. The UN statistics that are relied upon are up to date as of 9 January 2024. In South Africa's oral submissions, we will illustrate the facts that we rely on with limited use of audiovisual material. Madam President, we do so with restraint and only where necessary, and always with respect to the Palestinian people. Against this background, I move now to demonstrate, in turn, how Israel's conduct violates Articles 2A, 2B, 2C, and 2D of the Convention. The first genocidal act committed by Israel is the mass killing of Palestinians in Gaza, in violation of Article 2A of the Genocide Convention. As the UN Secretary General explained 5 weeks ago, the level of Israel's killing is so extensive that nowhere is safe in Gaza. As I stand before you today, 23,210 Palestinians have been killed by Israeli forces during the sustained attacks over the last 3 months. At least 70% of whom are believed to be women and children. Some 7,000 Palestinians are still missing, presumed dead under the rubble. Palestinians in Gaza are subjected to relentless bombing wherever they go. They are killed in their homes, in places where they seek shelter, in hospitals, in schools, in mosques, in churches, and as they try to find food and water for their families. They have been killed if they failed to evacuate. In the places to which they have fled, and even while they attempted to flee along Israeli-declared safe routes. The level of killing is so extensive that those whose bodies are found are buried in mass graves, often unidentified. In the first 3 weeks alone, following 7 October, Israel deployed 6,000 bombs per week. At least 200 times it has deployed 2,000-pound bombs in southern areas of Palestine designated as safe. These bombs have also decimated the north, including refugee camps. 2,000-pound bombs are some of the biggest and most destructive bombs available. They are dropped by lethal fighter jets that are used to strike targets on the ground by one of the world's most resourced armies. Israel has killed an unparalleled and unprecedented number of civilians, with the full knowledge of how many civilian lives each bomb will take. More than 1,800 families, Palestinian families in Gaza, have lost multiple family members, and hundreds of multi-generational families have been wiped out, with no remaining survivors. Mothers, fathers, children, siblings, grandparents, aunts, cousins, often all killed together. This killing is nothing short of destruction of Palestinian life. It is inflicted deliberately. No one is spared, not even newborn babies. The scale of Palestinian child killings in Gaza is such that UN chiefs have described it as a graveyard for children. The devastation, we submit, is intended to and has laid waste to Gaza beyond any acceptable legal, let alone humane, justification. The second genocidal act identified in South Africa's application is Israel's infliction of serious bodily or mental harm to Palestinians in Gaza in violation of Article 2B of the Genocide Convention. Israel's attacks have left close to 60,000 Palestinians wounded and maimed. Again, the majority of them women and children. This in circumstances where the healthcare system has all but collapsed. I'll return to this later in my speech. Large numbers of Palestinian civilians, including children, are arrested, blindfolded, forced to undress, and loaded onto trucks, taken to unknown locations. The suffering of the Palestinian people, physical and mental, is undeniable. Turning to the third genocidal act under Article 2C. Israel has deliberately imposed conditions on Gaza that cannot sustain life and are calculated to bring about its physical destruction. Israel achieves this in at least 4 ways. First, by displacement. Israel has forced the displacement of about 85% of Palestinians in Gaza. There is nowhere safe for them to flee to. Those who cannot leave or refuse to be displaced have either been killed or at extreme risk of being killed in their homes. Many Palestinians have been displaced multiple times as families are forced to move repeatedly in search of safety. Israel's first evacuation order on 13 October required the evacuation of over 1 million people, including children, the elderly, the wounded, and infirm. Entire hospitals were required to evacuate, even newborn babies in intensive care. The order required them to evacuate the north to the south within 24 hours. The order itself was genocidal. It required immediate movement, taking only what could be carried, while no humanitarian assistance was permitted, and fuel, water, and food, and other necessities of life had deliberately been cut off. It was clearly calculated to bring about the destruction of the population. For many Palestinians, the forced evacuation from their homes is inevitably permanent. Israel has now damaged or destroyed an estimated 355,000 Palestinian homes, leaving at least 500,000 Palestinians with no home to return to. The Special Rapporteur on the Human Rights of Internally Displaced Persons explains that houses and infrastructure, I quote, have been razed to the ground, frustrating any realistic prospects for displaced Gazans to return home, repeating a long history of mass forced displacement of Palestinians by Israel. There is no indication at all that Israel accepts responsibility for rebuilding what it has destroyed. Instead, the destruction is celebrated by the Israeli army. Soldiers film themselves joyfully detonating entire apartment blocks and town squares, erecting the Israeli flag over the wreckage, seeking to re-establish Israeli settlements on the rubble of Palestinian homes, and thus extinguishing the very basis of Palestinian life in Gaza. Second, together with the forced displacement, Israel's conduct has been deliberately calculated to cause widespread hunger, dehydration, and starvation. Israel's campaign has pushed Gazans to the brink of famine. An unprecedented 93% of the population in Gaza is facing crisis levels of hunger. Of all the people in the world currently suffering catastrophic hunger, more than 80% are in Gaza. The situation is such that the experts are now predicting that more Palestinians in Gaza may die from starvation and disease than airstrikes. And yet Israel continues to impede the effective delivery of humanitarian assistance to Palestinians, not only refusing to allow sufficient aid in, but removing the ability to distribute it through constant bombardment and obstruction. Just 3 days ago, on 8 January, a planned mission by UN agencies to deliver urgent medical supplies and vital fuel to a hospital and medical supply center was denied by Israeli authorities. This marked the 5th denial of a mission to the center since 26 December, leaving 5 hospitals in northern Gaza without access to life-saving medical supplies and equipment. Aid trucks that are allowed in are seized upon by the hungry. What is provided is simply not enough. Madam President, members of the court, this is an image of an aid truck arriving in Gaza. Third, Israel has deliberately inflicted conditions in which Palestinians in Gaza are denied adequate shelter, clothes, or sanitation. For weeks, there have been acute shortages of clothes, bedding, blankets, and critical non-food items. Clean water is all but gone, leaving far below the amount required to safely drink, clean, and cook. Accordingly, the WHO has stated that Gaza is experiencing soaring rates of infectious disease outbreaks. Cases of diarrhea in children under 5 years of age have increased 2,000% since hostilities began. When combined and left untreated, malnutrition and disease create a deadly cycle. The fourth genocidal act under Article 2B is Israel's military assault on Gaza's healthcare system, which renders life unsustainable. Even by 7 December, the UN Special Rapporteur on the right to health noted that the healthcare infrastructure in the Gaza Strip has been completely obliterated. Those wounded by Israel in Gaza are being deprived of life-saving medical care. Gaza's healthcare system, already crippled by years of blockade and prior attacks by Israel, is unable to cope with the sheer scale of the injuries. Finally, the UN Special Rapporteur on Violence Against Women and Girls has pointed to acts committed by Israel that would fall under the fourth category of genocidal acts in Article 2D of the Convention. On 22 November, she expressly warned the following: the reproductive violence inflicted by Israel on Palestinian women, newborn babies, infants, and children could be qualified as acts of genocide under Article 2 of the Genocide Convention, including imposing measures intended to prevent births within a group. Israel is blocking the delivery of life-saving aid, including essential medical kits for delivering babies, in circumstances where an estimated 180 women are giving birth in Gaza each day. Of these 180 women, the WHO warns that 15% are likely to experience pregnancy or birth-related complications and need additional medical care. That care is simply not available. In sum, Madam President, all of these acts, individually and collectively, form a calculated pattern of conduct by Israel, indicating a genocidal intent. This intent is evident from Israel's conduct in specially targeting Palestinians living in Gaza, using weaponry that causes large-scale homicidal destruction, as well as targeted sniping of civilians, designating safe zones for Palestinians to seek refuge, and then bombing these, depriving Palestinians in Gaza of basic needs: food, water, healthcare, fuel, sanitation, and communications, destroying social infrastructure, homes, schools, mosques, churches, hospitals, and killing, seriously injuring, and leaving large numbers of children orphaned. Genocides are never declared in advance. But this court has the benefit of the past 13 weeks of evidence that shows incontrovertibly a pattern of conduct and related intention that justifies a plausible claim of genocidal acts. In the Gambia-Myanmar case, this court did not hesitate to impose provisional measures in relation to allegations that Myanmar was committing genocidal acts against the Rohingya within the Rakhine state. The facts before the court today are sadly even more stark, and like the Gambia-Myanmar case, deserve and demand this court's intervention. Every day, there is mounting irreparable loss of life, property, dignity, and humanity for the Palestinian people. Our news feeds show graphic images of suffering that has become unbearable to watch. Nothing will stop the suffering except an order from this court. Without an indication of provisional measures, the atrocities will continue, with the Israeli Defense Force indicating that it intends pursuing this course of action for at least a year. In the words of the UN Under-Secretary General on 5 January 2024, I quote, "You think getting aid into Gaza is easy? Think again. 3 layers of inspections before trucks can even enter. Confusion and long queues. A growing list of rejected items. A crossing point meant for pedestrians, not trucks. Another crossing point where trucks have been blocked by desperate, hungry communities. A destroyed commercial sector. Constant bombardments, poor communications, damaged roads, convoys shot at, delays at checkpoints, a traumatized and exhausted population crammed into a smaller and smaller sliver of land, shelters which have long exceeded their full capacity, aid workers themselves displaced, killed. This is an impossible situation for the people of Gaza and for those trying to help them. The fighting must stop." Close quote. Madam President, members of the court, that concludes my section on the genocidal conduct of Israel. I thank you for your patient attention, and I ask that you call Advocate Mokhiber to the podium to address the court on genocidal intent.
I thank Ms. Hassim, and I now invite Mr. Tembeke Mokhiber to address the court. You have the floor, sir.
Madam President and distinguished members of the court, it is a privilege to appear before the court on behalf of South Africa. I will address Israel's genocidal intent. At this stage, the court is not required to determine that the only inference to be drawn from the available evidence is genocidal to order provisional measures, as that is to decide the merits. Rather, the assessment of the existence of an intent to destroy could be made by the court only at the stage of the examination of the merits. That some of the alleged acts may also amount to atrocities other than genocide does not exclude the finding of plausible acts of genocide. Madam President, South Africa is not alone in drawing attention to Israel's genocidal rhetoric against Palestinians in Gaza. 15 United Nations special rapporteurs and 21 members of the United Nations working groups have warned that what is happening in Gaza reflects a genocide in the making. and an overt intent to destroy the Palestinian people under occupation. Israel has a genocidal intent against the Palestinians in Gaza. That is evident from the way in which Israel's military attack is being conducted, which has been described by Ms. Hassim SC. It is systematic in its character and form. The mass displacement of the population of Gaza, headed into areas where they continue to be killed, and the deliberate creation of conditions that, quote, lead to a slow death, unquote. There is also the clear pattern of conduct, the targeting of family homes and civilian infrastructure, laying waste to vast areas of Gaza, and the bombing, shelling, and sniping of men, women, and children where they stand, the destruction of the health infrastructure, and lack of access to humanitarian assistance. So much so that as we stand today, 1% of the Palestinian population in Gaza has been systematically decimated, and 1 in 4 Gazans have been injured since 7 October. These 2 elements alone are capable of evidencing Israel's genocidal intent in relation to the whole or part of the Palestinian population in Gaza. However, third, there is an extraordinary feature in this case, that Israel's political leaders, military commanders, and persons holding official positions have systematically and in explicit terms declared their genocidal intent. And these statements are then repeated by soldiers on the ground in Gaza as they engage in the destruction of Palestinians and the physical infrastructure of Gaza. We show this third element next. Israel's special genocidal intent is rooted in the belief that, in fact, the enemy is not just the military wing of Hamas, or indeed Hamas generally, but is embedded in the fabric of Palestinian life in Gaza. On 7 October, in a televised address, Israeli Prime Minister Benjamin Netanyahu declared war on Gaza, and I quote, "Israel had started clearing out the communities that have been infiltrated by terrorists." And he warned of an unprecedented price to be paid by the enemy. There are more than 2.3 million Palestinians in Gaza. Israel is the occupying power in control of Gaza. It controls entry, exit, and the internal movements of inside Gaza. And Prime Minister, Mr. Netanyahu exercises overall command over the Israeli Defense Force and, in turn, the Palestinians in Gaza. Prime Minister Netanyahu, in his address to the Israeli forces on 28 October 2023, preparing for the invasion of Gaza, urged the soldiers to remember what Amalek has done to you. This refers to the biblical command by God to Saul for the retaliatory destruction of an entire group of people known as the Amalekites. put to death men and women, children and infants, cattle and sheep, camels and donkeys. The genocidal invocation to Amalek was anything but idle. It was repeated by Mr. Netanyahu in a letter to the Israeli Armed Forces on 3 November 2023. Madam President, let the Prime Minister's words speak for themselves.
Has done to you, says our Holy Bible, and we do remember and we are fighting our brave troops and combatants who are now in Gaza or around Gaza and
The Deputy Speaker of the Knesset, Israel's parliament, has called for the erasure of the Gaza Strip from the face of the earth. The Defense Force agrees. On 9 October, the Defense Minister, Yoav Gallant, gave a situation update to the army, where he said that as Israel was imposing a complete siege on Gaza, there would be no electricity, no food, no water, no fuel. Everything would be closed because Israel is fighting human animals. Speaking to troops on the Gaza border, he instructed them that he has released all the restraints and that Gaza won't return to what it was before. We will eliminate everything. We will reach all places. Eliminate everything. Reach all places without any restraints. The theme of destruction of human animals was reiterated by an Israeli army coordinator of government activities in the territories on 9 October 2023, who, in an address to Hamas and the residents of Gaza, stated that Hamas has become ISIS and that the citizens of Gaza are celebrating instead of being horrified. He concluded that human animals are dealt with accordingly. Israel has imposed a total blockade on Gaza. No electricity, no water, just damage. You wanted hell, you will get hell. The language of systematic dehumanization is evident here. Human animals. Both Hamas and civilians are condemned. Within the Israeli cabinet, this is also a widely held view. The Minister of Energy and Infrastructure, Israel Katz, called for the denial of water and fuel, as this is what will happen to a people of children killers and slaughterers. This admits of no ambiguity. It means to create conditions of death of the Palestinian people in Gaza. To die a slow death because of starvation and dehydration, or to die quickly because of a bomb attack or snipers, but to die nevertheless. In fact, Heritage Minister Amichai Eliyahu said that Israel must find ways for Gazans that are more painful than death. It is no answer to say that neither are in command of the army. They are ministers in the Israeli government. They vote in the Knesset and are in a position to shape state policy. The intent to destroy Gaza has been nurtured at the highest levels of state, as President Isaac Herzog has joined the ranks of those signing bombs destined for Gaza. Having previously noted that the entire population in Gaza is responsible and that this rhetoric about civilians not aware, not involved is absolutely not true, we will fight until we break their backbone. Later attempts by the President and others to neutralize this speech have not altered the sting of his words, which was to tar all Palestinians as responsible for the actions of Hamas. No, as I will show below, has it affected how state policy is understood within government? The Minister of National Security repeated the President's statements that Hamas and civilians are responsible in equal measure. On 10 November 2023, in a televised interview, he stated that when we say that Hamas should be destroyed, it also means those who celebrate, those who support, and those who hand out candy. They are all terrorists, and they should also be destroyed. These are orders to destroy and to maim what cannot be destroyed. These statements are not open to neutral interpretations or after-the-fact rationalizations and reinterpretations by Israel. The statements were made by persons in command of the state. They communicated state policy. It is simple. If the statements were not intended, they would not have been made. The genocidal intent behind these statements is not ambiguous to the Israeli soldiers on the ground. Indeed, it is directing their actions and objectives. On 7 December 2023, Israeli soldiers proved that they understood the Prime Minister's message to remember what the Amalek has done to you as genocidal. They were recorded by journalists dancing and singing. We know our motto, there are no uninvolved, that they obey one commandment, to wipe off the seed of Amalek. The Prime Minister's invocation of Amalek is being used by soldiers to justify the killing of civilians, including children. These are the soldiers repeating the inciting words of their Prime Minister. Israeli soldiers in Gaza were filmed dancing, chanting, and singing in November. May their village burn, may Gaza be erased. There is now a trend among the soldiers to film themselves committing atrocities against civilians in Gaza in a form of snuff video. One recorded himself detonating over 50 houses in Shujaiya. Other soldiers were recorded singing, "We will destroy all of Khan Yunis and this house. We will blow it up for you and for everything you do for us." These are the soldiers putting into effect their command.
שכונת סג'איה ז"ל, נחל עוז, בעזרת השם יהיה לכם.
חטיבה 828, אומרת לסג'איה שלום.
מדהים. 30 בתים, גדוד 749.
כאן מתחיל הניצחון. עם ישראל חי.
The commanders of the army are also of the same mind. Israeli army commander Yair Ben David has stated that the army had done in Beit Hanon and did there as Shimon and Levi did in Nablus. and that the entire Gaza should resemble Beit Hanun. Israeli soldier Yeshai Shalev published a video against the backdrop of the ruins of what was the site of Al-Azhar University with the caption, "Once upon a time, there was a university in Gaza, and in practice, a school for murderers and human animals." Soldiers obviously believe that this language and their actions are acceptable because the destruction of Palestinian life in Gaza is articulated state policy. Senior political and military officials encouraged without censure the 95-year-old Israeli army reservist Ezra Yachin, a veteran of the Deir Yassin massacre against the Palestinians in 1948, to speak to the soldiers ahead of the ground invasion in Gaza. In his tour, he echoed the same sentiment while being driven around in an officially Israeli army vehicle, dressed in Israeli army fatigue. I quote, "Be triumphant and finish them off, and don't leave anyone behind. Erase the memory of them. Erase them, their families, mothers and children. These animals can no longer live. If you have an Arab neighbor, don't wait, go to his home and shoot him. We want to invade, not like before. We want to enter and destroy what's in front of us, and destroy houses, then destroy the one after it. With all of our forces, complete destruction, enter and destroy. As you can see, we will witness things we've never dreamed of. Let them drop bombs on them and erase them." As recently as 7 January 2024, a video of a soldier was posted online where he boasts that the army had destroyed the entire village of Hibat Azar. For 2 weeks, he said, they had worked hard to bomb the village and executed their mandate. Any suggestion that senior politicians did not mean what they said, much less that the meaning was not understood by soldiers in Gaza, would be without any merit. The scale of destruction in Gaza, the mass targeting of family homes and civilians, the war being a war on children, all make clear that genocidal intent is both understood and is being put into practice. The articulated intent is the destruction of Palestinian life in all its manifestations. The genocidal rhetoric is also commonplace within the Israeli Knesset. Members of the Knesset have repeatedly called for Gaza to be wiped out, flattened, erased, and crushed on all its inhabitants. They have deplored anyone feeling sorry for the uninvolved Gazans, asserting repeatedly that there are no uninvolved, that there are no innocents in Gaza, that the killers of the women and children should not be separated from the citizens of Gaza, and that the children of Gaza have brought this upon themselves, and that there should be one sentence for everyone there, death. Finally, the lawmakers have called for mercilessly bombing from the air, with some advocating for the use of nuclear doomsday weapons, and a Nakba that will overshadow the Nakba of 48. The Prime Minister's genocidal speech has gained ground among some elements of civil society. A famous singer has repeated Mr. Netanyahu's Amalek reference, stating that Gaza must be wiped out and be destroyed with every Amalek seed. We simply must destroy all of Gaza and exterminate everyone who is there. Another has called to erase Gaza, not leave a single person there. Journalists and commentators have announced that the woman is an enemy, the baby is an enemy, the pregnant woman is an enemy, that it is necessary to turn the strip into a slaughterhouse, to demolish every house our soldiers come across, exterminate everyone. The intentional failure of the government of Israel to condemn, prevent, and punish such genocidal incitement constitutes in itself a grave violation of the Genocide Convention. We should recall, Madam President, that in Article 1 of the Convention, Israel confirmed that genocide, whether committed in time of peace or in time of war, is a crime under international law. And it undertook to prevent and to punish it as such. This failure to prevent, condemn, and punish such speech by the government has served to normalize genocidal rhetoric and extreme danger for Palestinians within Israeli society. As MK Moshe Sada from the Likud party has said, the government's own attorneys share his views that Palestinians in Gaza must be destroyed. I quote, "You go anywhere and they tell you to destroy them. In the kibbutz, they tell you to destroy them. My friends at the state attorney's office who fought with me on political issues in debate said to me, it is clear that we need to destroy all Gazans. Destroy all Gazans." Israel is aware of its destruction of Palestinian life and infrastructure. Despite this knowledge, it has maintained and indeed intensified its military activity in Gaza. As to full awareness, in the week after 7 October, NGOs and the United Nations warned of an unprecedented humanitarian crisis in Gaza. The UN stated that actors must allow humanitarian teams and goods to immediately and safely reach the hundreds of thousands of people in need. So right from the beginning, Israel knew that it was depriving water, food, electricity, and essentials for survival. It said so. Everything is closed. It has known that it was depriving Palestinians of health care and treatment for injury in the middle of an unprecedented bombardment, of food and water, and of other essentials for survival. This prompted the World Health Organization to say, "We are on our knees asking for sustained, scaled-up, protected humanitarian operations, appealing to all those in a situation to make a decision or influence decision makers to give us the humanitarian space to address this human catastrophe." Despite this knowledge, Israel continues to target infrastructure essential for survival: water and sanitation infrastructure, solar panels, bakeries, mills, crops. It bombs hospitals, decimating the healthcare system. It targets aid workers and the infrastructure of the United Nations. It is because of the policy of Israel that Gaza has become a place of death and despair. In conclusion, Madam President, many propagators of grave atrocities have protested that they were misunderstood, that they did not mean what they said, and that their own words were taken out of context. What state would admit to a genocidal intent? Yet, the distinctive feature of this case has not been the silence as such, but the reiteration and repetition of genocidal speech throughout every sphere of state in Israel. We remind the court of the identity and authority of the genocidal inciters: the Prime Minister, the President, the Minister of Defense, the Minister of National Security, the Minister of Energy and Infrastructure, members of the Knesset, senior army officials, and foot soldiers. Genocidal utterances are therefore not out in the fringes. They are embodied in state policy. The intent to destroy is plainly understood by soldiers on the ground. It is also fully understood by some within the Israeli society, with the government facing criticism for allowing in any aid to Gaza on the basis that it is recanting on its promise to starve Palestinians. Any suggestion that Israeli officials did not mean what they said or were not fully understood by soldiers and civilians alike to mean what they said should be rejected by this court. The evidence of genocidal intent is not only chilling, it is also overwhelming and incontrovertible. Madam President, it is now my honor to request you to call Mr. John Dugard on the subject of jurisdiction.
I thank Mr. Ngukai Toby, and I now invite Professor
to breathe, y'all. And then, so this is the part that I originally said that was our first two speakers. If you have to slip out, this is not a bad time to do so. But otherwise, given the news that we just received, what we're going to do is I'm going to skip directly to the fourth speaker, the Irish lawyer, Blinny, since I think her section is one of the other most important after the first two. That will take us to about 8 o'clock. If anyone wants to leave to go join the emergency protest, I believe we'll have someone here who will be walking everyone over there. I will probably stick around and show the rest of the program for whoever wants it. And I also suggest, as a little intermission, that you turn to the person next to you or the closest person that you don't know and introduce yourself or say what brought you here, and just connect with each other for 5 seconds after watching what we just watched. All right. All right. I'm sure y'all are having excellent discussions. You can keep them going if you'd like. I'm going to go ahead and press play on the video. This is, again, the section of the presentation about the imminent danger to the Palestinian people.
Madame President, members of the court, it is a great honor for me to appear before the court once again. It is also both a privilege and a weighty responsibility for me to represent South Africa in this case of such severe gravity. It is my task to examine the urgency and the risk of irreparable harm to the rights claimed, the final two conditions to be met for the court to indicate provisional measures. Before that, I should like to address South Africa's sincere apologies to the Francophone members of the court for not having made any of its submissions in French. South Africa would ask you not to regard this as a lack of courtesy on its part. If you will allow, I shall now continue my pleadings in English.
Madam President, members of the court, there is an urgent need for provisional measures to protect Palestinians in Gaza from the irreparable prejudice caused by Israel's violations of the Genocide Convention. The United Nations Secretary-General and its chiefs describe the situation in Gaza variously as a crisis of humanity, a living hell, a bloodbath, a situation of utter deepening and unmatched horror, where an entire population is besieged and under attack, denied access to the essentials for survival on a massive scale. As the United Nations Under-Secretary-General for Humanitarian Affairs stated last Friday, and I quote, "Gaza has become a place of death and despair. Families are sleeping in the open as temperatures plummet. Areas where civilians were told to relocate for their safety have come under relentless bombardment. Medical facilities are under relentless attack. The few hospitals that are partially functional are overwhelmed with trauma cases, critically short of all supplies, and inundated by desperate people seeking safety. A public health disaster is unfolding. Infectious diseases are spreading in overcrowded shelters as sewers spill over. Some 180 women are giving birth daily amidst this chaos. People are facing the highest levels of food insecurity ever recorded. Famine is around the corner. For children in particular, the last 12 weeks have been traumatic. No food, no water, no school, nothing but the terrifying sounds of war, day in and day out. Gaza has simply become uninhabitable. Its people are witnessing daily threats to their very existence, while the world watches on." End quote. The court has heard of the horrific death toll and of the more than 7,000 Palestinian men, women and children reported missing, presumed dead or dying slow, excruciating deaths trapped under the rubble. Reports of field executions and torture and ill treatment are mounting, as are images of decomposing bodies of Palestinian men, women and children left unburied where they were killed, some being picked upon by animals. It is becoming ever clearer that huge swathes of Gaza, entire towns, villages, refugee camps, are being wiped from the map. As you have heard, but it bears repeating, according to the World Food Programme, 4 out of 5 people in the world in famine or a catastrophic type of hunger are in Gaza right now. Indeed, experts warn that deaths from starvation and disease risk significantly outstripping deaths from bombings. The daily statistics stand as clear evidence of the urgency and of the irreparable prejudice. On the basis of the current figures, on average, 247 Palestinians are being killed and are at risk of being killed each day, many of them literally blown to pieces. They include 48 mothers each day, 2 every hour, and over 117 children each day, leading UNICEF to call Israel's actions a war on children. On current rates which show no sign of abating, each day, over 3 medics, 2 teachers, more than 1 United Nations employee, and more than 1 journalist will be killed, many while at work or in what appear to be targeted attacks on their family homes or where they are sheltering. The risk of famine will increase each day. Each day, an average of 629 people will be wounded, some multiple times over, as they move from place to place, desperately seeking sanctuary. Each day, over 10 Palestinian children will have 1 or both legs amputated, many without anaesthetic. Each day, on current rates, an average of 3,900 Palestinian homes will be damaged or destroyed. More mass graves will be dug. More cemeteries will be bulldozed and bombed and corpses violently exhumed, denying even the dead any dignity or peace. Each day, ambulances, hospitals and medics will continue to be attacked and killed. The first responders who have spent 3 months without international assistance, trying to dig families out of the rubble with their bare hands, will continue to be targeted. On current figures, 1 will be killed almost every second day, sometimes in attacks launched against those attending the scene to rescue the wounded. Each day, yet more desperate people will be forced to relocate from where they are sheltering, or will be bombed in places where they have been told to evacuate to. Entire multi-generational families will be obliterated, and yet more Palestinian children will become WCNSF, Wounded Child, No Surviving Family, the terrible new acronym born out of Israel's genocidal assault on the Palestinian population in Gaza. There is an urgent need for provisional measures to prevent imminent, irreparable prejudice to the rights in issue in this case. There could not be a clearer or more compelling case. In the words of the Commissioner General of the United Nations Relief and Works Agency, there must be an end to the decimation of Gaza and of its people. Turning to the Court's case law, as the Court has recently reaffirmed, and I quote, "The condition of urgency is met when acts susceptible of causing irreparable prejudice can occur at any moment before the Court makes a final decision on the case." End quote. That is precisely the situation here. Any of those matters to which I have referred can and are occurring at any moment. United Nations Security Council resolutions demanding, quote, "the immediate, safe, unhindered delivery of humanitarian assistance at scale throughout Gaza and full, rapid, safe and unhindered humanitarian access," end quote, remain unimplemented. United Nations General Assembly resolutions calling for a humanitarian ceasefire have been ignored. The situation could not be more urgent. Since these proceedings were initiated on the 29th of December 2023 alone, an estimated over 1,703 Palestinians have been killed in Gaza and over 3,252 injured. As to the criterion of irreparable prejudice, for decades now, the Court has repeatedly found it to be satisfied in situations where serious risks arise to human life or to other fundamental rights. In the cases of Georgia, Russia, and Armenia, Azerbaijan, the Court ordered provisional measures, having found a serious risk of irreparable prejudice where hundreds of thousands of people had been forced from their homes. In ordering provisional measures in the latter case, the court noted the context of, I quote, the long-standing exposure of the population to a situation of vulnerability, including hindrances to the importation of essential goods, causing shortages of food, medicine, and other life-saving medical supplies, end quote. In Gaza, as you have heard, nearly 2 million people, over 85% of the population, have been repeatedly forced to flee their homes and shelters, not just once or twice, but some 3, 4, or more times over, into shrinking slivers of land where they continue to be bombed and killed. This is a population that Israel had already made vulnerable through 16 years of military blockade and crippling de-development. Today, Israel's hindrances to the import of food and essential items have brought Gaza to the brink of famine, with adults, mothers, fathers, grandparents regularly foregoing food for the day so that children can eat at least something. Medicine shortages and the lack of medical treatment, clean water and electricity are so great that large numbers of Palestinians are dying or are at imminent risk of dying preventable deaths. Cancer and other services have long shut down. Women are undergoing caesarean sections without anaesthetic in barely functioning hospitals, described as scenes from a horror movie, with many undergoing otherwise unnecessary hysterectomies in an attempt to save their lives. In the Canada-Syria torture case, the court made clear that, I quote, individuals subject to torture and other acts of cruel, inhuman or degrading treatment or punishment are at serious risk of irreparable prejudice. Well, Palestinians in Gaza are also at risk of such irreparable prejudice, with videos of Palestinian boys and men rounded up and stripped and degraded broadcast to the world, alongside footage of serious bodily harm and accounts of serious mental harm and humiliation. In Qatar, United Arab Emirates, the court considered provisional measures to be justified, having regard to the risk of irreparable prejudice deriving from factors such as people being forced to leave their places of residence without the possibility of return, the psychological distress of temporary or potentially ongoing separation from their families, and the harm associated with students being prevented from taking their exams. If provisional measures were justified there, how could they not be in Gaza, where countless families have been separated, with some family members evacuating under Israeli military orders and others staying behind at extreme risk to care for the wounded, infirm and the elderly, where husbands, fathers and sons are being rounded up and separated from their families, taken to unknown locations for indeterminate periods of time. In the Qatar case, the court issued a provisional order where harm to approximately 150 students was an issue. In Gaza, 625,000 school children have not attended school for 3 months, with the United Nations Security Council expressing deep concern, I quote, that the disruption of access to education has a dramatic impact on children and that conflict has lifelong effects on their physical and mental health. Almost 90,000 Palestinian university students cannot attend at university in Gaza. Over 60% of schools, almost all universities, and countless bookshops and libraries have been damaged or destroyed, and hundreds of teachers and academics have been killed, including deans of universities and leading Palestinian scholars, obliterating the very prospects for the future education of Gaza's children and young people. Notably, the court has found provisional measures to be justified in all 3 cases where they were previously sought in relation to violations of the Genocide Convention. It did so in Bosnia and Serbia in 1993, finding on the basis of evidence that was certainly no more compelling than that presently before the court, that it was sufficient to determine that there was, and I quote, a grave risk of acts of genocide being committed. The court found provisional measures to be justified in the Gambia-Myanmar case on the basis of a risk of irreparable prejudice to the Rohingya, subject to, quote, mass killings as well as beatings, the destruction of villages and homes, denial of access to food, shelter, and other essentials of life. More recently, in indicating provisional measures in Ukraine-Russia, the court considered that Russia's military activities had, quote, resulted in numerous civilian deaths and injuries and caused significant material damage, including the destruction of buildings and infrastructure, end quote, giving rise to a risk of irreparable prejudice. The court had regard to the fact that, quote, attacks are ongoing and are creating increasingly difficult living conditions for the civilian population, end quote, which it considered to be extremely vulnerable. The court also considered the fact that, I quote again, many persons have no access to the most basic foodstuffs, potable water, electricity, essential medicines or heating, and that many were attempting to flee under extremely insecure conditions. This is occurring in Gaza on a much more intensive scale to a besieged, trapped, terrified population that has nowhere safe to go. Lest the contrary be suggested, it is clear from Ukraine-Russia that the fact that the urgent risk of irreparable harm arises in a situation of armed conflict does not undermine, much less preclude, a request for provisional measures. That's also clear from the court's other judgments. So in the case of armed activities on the territory of the Congo, for example, the court ordered provisional measures based on its finding that, quote, persons, assets and resources present on the territory of the Congo, particularly in the area of conflict, remain extremely vulnerable, and that there was a serious risk that rights at issue in the case may suffer irreparable prejudice, end quote. Similarly, in Costa Rica, Nicaragua, the court indicated provisional measures in part on the basis that the presence of troops in the disputed territory gave rise, I quote, to a real and present risk of incidents liable to cause irremediable harm in the form of bodily injury or death, end quote. In relation to the Genocide Convention in particular, the court recalled in Gambia, Myanmar, that, quote, states parties expressly confirmed their willingness to consider genocide as a crime under international law, which they must prevent and punish independently of the context of peace or of war in which it takes place, end quote. More recently, in the case of Guyana, Venezuela, the court considered that the serious risk of Venezuela, quote, acquiring and exercising control and administration of the territory in dispute, end quote, gave rise to a risk of irreparable prejudice to the rights asserted in the case. Similar factors are an issue here, having regard to the territorial ambitions and settlement plans for Gaza being raised by members of the Israeli government, and the relationship of those factors to the very survival of Palestinians in Gaza as such. Similarly, any scaling up by Israel of access of humanitarian relief to Gaza in response to these proceedings or otherwise would be no answer to South Africa's request for provisional measures. In the case of Iran, United States, the court found a risk of irreparable harm from the exposure of individuals to danger to health and life caused by restrictions placed on medicines and medical devices, foodstuffs, and other goods required for humanitarian needs. That was notwithstanding the assurances offered by the United States for it to expedite the consideration of humanitarian issues, and notwithstanding the fact that essentials were in any event exempt from the United States sanctions. The Court considered that the assurances were, I quote, not adequate to address fully the humanitarian and safety concerns raised, and that there remained a risk that measures adopted by the United States may entail irreparable consequences. In Armenia, Azerbaijan, unilateral undertakings to alleviate restrictions alongside the full resumption of humanitarian and commercial deliveries did not defeat requests for the indication of provisional measures. The Court was clear that while contributing, quote, towards mitigating the imminent risk of irreparable prejudice resulting from the military operation, those developments did not remove the risk entirely. Indeed, in Georgia, Russia, the Court made clear that it considers a serious risk to subsist where, quote, the situation is unstable and could rapidly change. The Court considered, quote, given the ongoing tension and the absence of an overall settlement to the conflict in this region, populations also remain vulnerable, end quote. Israel continues to deny that it is responsible for the humanitarian crisis it has created, even as Gaza starves. The aid it has belatedly begun to allow in is wholly inadequate and does not come anywhere close to the average 500 trucks being permitted daily before October 2023, even under the blockade. Any unilateral undertakings Israel might seek to give about future aid would not remove the risk of irreparable prejudice, not least considering Israel's past and current conduct towards the Palestinian people, including the 16 years of brutal siege on Gaza. In any event, as the United Nations Secretary-General has made absolutely clear, it is a mistake to measure, quote, the effectiveness of the humanitarian operation in Gaza based on the number of trucks allowed in. As he stressed, I quote, the real problem is that the way Israel is conducting this offensive means that the conditions for the effective delivery of humanitarian aid no longer exist. That would require security, staff who can work in safety, logistical capacity, and the resumption of commercial activity. It requires electricity and steady communications. All of these remain absent, end quote. Indeed, only shortly after Israel opened the Kerem Shalom crossing to goods in late December 2023, it was struck in a drone attack, killing 5 Palestinians and leading to another temporary closure. Nowhere and nobody is safe. As the United Nations Secretary-General and all its chiefs have made clear, without a halt to Israel's military operations, crossings, aid convoys and humanitarian workers, like everyone and everything else in Gaza, remain at imminent risk of further irreparable prejudice. An unprecedented 148 United Nations staff have been killed to date. Without a halt to Israel's military activity in Gaza, there will be no end to the extreme situation facing Palestinian civilians. Madam President, members of the Court, if the indication of provisional measures was justified on the facts in those cases I have cited, how could it not be here, in a situation of much greater severity, where the imminent risk of irreparable harm is so much greater? How could they not be justified in a situation that humanitarian veterans from crises spanning as far back as the killing fields of Cambodia, people who, in the words of the United Nations Secretary-General, have seen everything, if they say it is so utterly unprecedented that they are out of words to describe it? It would be a complete departure from the long and established line of jurisprudence that this court has firmly established and recently reconfirmed for the court not to order provisional measures in this case. The imminent risk of death, harm and destruction that Palestinians in Gaza face today and that they risk every day during the pendency of these proceedings, on any view justifies, indeed compels, the indication of provisional measures. Some might say that the very reputation of international law, its ability and willingness to bind and to protect all peoples equally, hangs in the balance.
Brief pause. We're not done, but so the current status is, for anyone who would like to go join the emergency protest at 8:30, we will be gathering downstairs in about 15 minutes. You don't need anything except your body and your voice. They'll have what they need for you, and then I think people will head over to Times Square. That will be I think right at the end of this section. So I'll say when it's 8:15, and whoever wants to go can go. I will stay here and show the rest of the screening for whoever wants to stay and watch the parts of this screening that we still have to see, and then maybe go and join the protesters at some point. But that's our current status.
But the Genocide Convention is about much more than legal precedent. It is also fundamentally about the confirmation and endorsement of elementary principles of morality. The Court recalled the 1946 General Assembly resolution on the crime of genocide, which made clear that, I quote, "Genocide is a denial of the right of existence of entire human groups, as homicide is the denial of the right to live of individual human beings. Such denial of the right of existence shocks the conscience of mankind, results in great losses to humanity in the form of cultural and other contributions represented by these human groups, and is contrary to moral law and to the spirit and aims of the United Nations." End quote. Notwithstanding the Genocide Convention's recognition of the need to rid the world of the odious scourge of genocide, the international community has repeatedly failed. It failed the people of Rwanda, it had failed the Bosnian people and the Rohingya, prompting this court to take action. It failed again by ignoring the early warnings of the grave risk of genocide to the Palestinian people, sounded by international experts since 19th of October of last year. The international community continues to fail the Palestinian people, despite the overt, dehumanizing, genocidal rhetoric by Israeli governmental and military officials, matched by the Israeli army's actions on the ground. Despite the horror of the genocide against the Palestinian people being live-streamed from Gaza to our mobile phones, computers, and television screens, the first genocide in history where its victims are broadcasting their own destruction in real time in the desperate, so far vain hope that the world might do something. Gaza represents nothing short of a moral failure, as described by the usually circumspect International Committee of the Red Cross. As underscored by United Nations chiefs, that failure has, I quote, repercussions not just for the people of Gaza, but for the generations to come who will never forget these over 90 days of hell and assaults on the most basic precepts of humanity. As stated by a United Nations spokesperson in Gaza last week, at the site of a hospital clearly marked with the symbol of the Red Crescent, where 5 Palestinians, including a 5-day-old baby, had just been killed. The world should be absolutely horrified. The world should be absolutely outraged. There is no safe space in Gaza, and the world should be ashamed. Madam President, members of the Court, in conclusion, I share with you two photographs. The first is of a whiteboard at a hospital in northern Gaza, one of the many Palestinian hospitals targeted, besieged and bombed by Israel over the course of the past 3 brutal months. The whiteboard is wiped clean of no longer possible surgical cases, leaving only a handwritten message by a Médecins Sans Frontières doctor which reads, "We did what we could. Remember us." The second photograph is of the same whiteboard after an Israeli strike on the hospital on the 21st of November that killed the author of the message, Dr. Mahmoud Abu Nujayla, along with 2 of his colleagues. Just over a month later, in a powerful sermon delivered from a church in Bethlehem on Christmas Day, the same day Israel had killed 250 Palestinians, including at least 86 people, many from the same family, massacred in a single strike on Maghazi refugee camp. Palestinian pastor Mundhir Ishaq addressed his congregation and the world, and he said, and I quote, "Gaza as we know it no longer exists. This is an annihilation. This is a genocide. We will rise. We will stand up again from the midst of destruction, as we have always done as Palestinians, though this is by far maybe the biggest blow we have received." But he said, "No apologies will be accepted after the genocide. What has been done has been done. I want you to look in the mirror and ask, where was I when Gaza was going through a genocide?" South Africa is here before this court in the Peace Palace. It has done what it could. It is doing what it can by initiating these proceedings, by seeking interim measures against itself as well as against Israel. South Africa now respectfully and humbly calls on this honourable court to do what is in its power to do, to indicate the provisional measures that are so urgently required to prevent further irreparable harm to the Palestinian people in Gaza, whose hopes, including for their very survival, are now vested in this court.
Madam President, members of the Court, I should like to thank you for your kind attention. I ask that you call Professor Lowe, KC, to the podium now to describe the provisional measures sought by South Africa on behalf of the Palestinian people.
I thank Ms.
I apologize for the choppiness of the screening this evening. With the news of the strikes on Yemen, things got a little upturned. So I think, Leah, are you good to take people down? Okay. So Leah here, if you can stand up, I think she's going to be taking everyone downstairs who wants to go to the protest. If you want to stay here, I will be here. Otherwise, I'll mention just for the sake of it. Now more than ever, we want people, if they can, to go to Washington, D.C. on the 13th to march on Washington, D.C., march on President Biden and tell him that we reject what he's doing. I don't know if they have bus tickets left. I think they probably have flyers downstairs. But if not, they don't? Okay, they're sold out of bus tickets, but I'll mention it anyway in case people have their own means, Amtrak, whatever. In case people want to join us there. And otherwise, if you can't do that, just about every Monday we meet here for a community organizing session. This screening was born out of this week's community organizing session. It was not, we did not have institutional funding here. We just had this room and we had a bunch of people who wanted to make this happen. And I want you to know that you all can make this happen as well. So if you want to join us, come join us on Monday at 6:30, and we will discuss other actions like this one, and you'll be able to organize other actions like this one and learn more about what we're planning for the rest of the week. Yeah, so I think that's all I have to say for now. To the fourth speaker, who is the rights in question speaker.
Please be seated. The sitting is resumed. I now give the floor to Professor Max Duplessis. You have the floor, Professor.
Madam President, distinguished members of the Court, it is a privilege to appear before you. It's truly my honor to represent South Africa in these proceedings. I will be focusing on the nature of the rights that South Africa seeks to preserve through its application and the link between such rights and the measures requested. As well established in the Court's jurisprudence, and most recently in this Court's decision in the Gambia case, for the Court to exercise its power to indicate provisional measures, the rights claimed by South Africa on the merits, and for which it is seeking protection, must be at least plausible. This threshold does not require the Court to determine definitively whether the rights which South Africa wishes to see protected exist. Rather, the rights asserted must merely be grounded in a possible interpretation of the Convention, and the Court must be concerned to preserve by such measures the rights which may subsequently be adjudged by it to belong to either party. Palestinians in Gaza, as a very substantial and important part of the Palestinian national, racial, and ethnical group, simply but profoundly are entitled to exist. As South Africa's ambassador pointed out in opening, to situate the right to exist and the threats to that right, requires the court to appreciate that this application by South Africa is brought within a particular context. What is happening in Gaza now is not correctly framed as a simple conflict between two parties. It entails instead destructive acts perpetrated by an occupying power, Israel, that has subjected the Palestinian people to an oppressive and prolonged violation of their right to self-determination for more than half a century. And those violations occur in a world where Israel, for years, has regarded itself as beyond and above the law. As the UN Special Rapporteur on the occupied Palestinian territories explained in 2022, and I quote, "The occupation by Israel has been conducted in profound defiance of international law and hundreds of United Nations resolutions with scant pushback from the international community." That context is important, as South Africa made clear in its application. Where the international community has failed Palestinians for so long, and despite Israel's willful defiance of Palestinians' rights, South Africa turns to this court, seeking to protect the core rights of Palestinians in Gaza to be protected from acts of genocide, attempted genocide, direct and public incitement to genocide, and complicity in and conspiracy to commit genocide. As the court knows, the Convention prohibits the destruction of a group or part of that group, including through killing, causing serious bodily and mental harm, and inflicting conditions of life calculated to bring about the group's physical destruction. Through these core rights, the Convention further protects the rights of its members to life and physical and mental integrity. Palestinians in Gaza, women, men, children, because of their membership in a group, are protected by the Convention, as is the group itself. And the core rights are violated and threatened by a remarkable set of facts outlined by my colleagues and set out in detail in South Africa's application with supporting evidence. In the speeches to this court today, South Africa has chosen, as you've heard, to avoid the showing of graphic videos and photos. It has decided against turning this court into a theatre for spectacle. It knows, as well as your excellencies, the temptation for both sides in a dispute to parade pictures to shock. But South Africa's application in this court today is built on a foundation of clear legal rights, not images. The detailed material before the court is marshalled to show a case for provisional measures based firmly on this court's prior decisions, and South Africa advances its case on the basis that Palestinians' rights are equally as worthy of protection on the unprecedented evidence before you as those of the victim groups that this honourable court has previously protected by its issuance of provisional measures in the past. The material confirms the rights in issue and their violation, that Israel has committed and is committing acts capable of being characterized as genocidal. You have heard from Ms. Hassim about direct extermination of thousands of people and children of the Palestinian population in Gaza since 7 October last year. And South Africa and the world together stand witness to the forced evacuation of over 85% of the population of Gaza from their homes, and the herding of them into ever smaller areas without adequate shelter or medical care to be attacked, killed, and harmed. So, the rights are immediately and urgently in need of protection because of the ongoing denial by Israel of the conditions necessary for life. It is difficult, with respect, to think of a clearer or more abundantly urgent case. Arif Hussein, the chief economist at the United Nations World Food Programme, chillingly warned a week ago, on the 3rd of January, and I quote, "I've been doing this," he said, "for the past 2 decades, and I've been to all kinds of conflicts and all kinds of crises. And for me, the situation in Gaza, is unprecedented because of, 1, the magnitude the scale, the entire population of a particular place. Second, the severity. And third, the speed at which this is happening, at which this has unfolded, is unprecedented. He concluded, in my life, I've never seen anything like this in terms of severity, in terms of scale, and then in terms of speed. Madam President, esteemed judges, the core rights on the evidence provided by South Africa in its application are demonstrably being violated. Multiple further statements by UN bodies and experts, as well as various expert human rights organizations and institutions and states, all of which are set out in South Africa's application, confirm as much. They collectively have considered the acts committed by Israel to be genocidal, or at the very least warned that the Palestinian people are at risk of genocide. Since the application was initiated, further states, 13 to date, including the Arab League and the Organization of Islamic Cooperation, representing 57 states, as well as other experts, have expressed their support for the case, thereby underlining the plausibility of South Africa's claim for provisional measures. For the purposes of the indication of provisional measures, the rights asserted by South Africa under the Genocide Convention and their protection corresponds with the very object and purpose of the Convention. Based on the materials before the court, the acts by Israel complained of are capable of being characterized as at least plausibly genocidal. As Mr. Mokhiber has explicated, the evidence of the specific genocidal intent is clear from the statements by Israeli government officials and soldiers towards Palestinians in Gaza, and which may be characterized as at the very least plausibly genocidal. This at least plausible genocidal intent can also be deduced from the pattern of conduct against Palestinians in Gaza. It is also, again at the very least, plausible that Israel has failed to prevent or to punish genocide, conspiracy to commit genocide, direct and public incitement to genocide, attempted genocide, and complicity in genocide. And it is further plausible that South Africa has an obligation to prevent genocide, including by taking all reasonable measures within its powers to influence effectively the actions of persons perpetrating and likely to commit genocide or engaging in direct or public incitement to genocide. So let me be clear. South Africa's obligation is motivated by the need to protect Palestinians in Gaza and their absolute rights not to be subjected to genocidal acts. Notwithstanding the incontestably serious nature of the allegations against Israel, the court should not be required, before granting provisional measures, to ascertain whether the existence of a genocidal intent is the only plausible inference to be drawn from the material before it. That would amount to the court making a determination on the merits. Moreover, South Africa has stressed that any motive or effort by Israel to destroy Hamas does not preclude genocidal intent by Israel towards the whole or part of the Palestinian people in Gaza. Evidence of other motives explaining its conduct as a perpetrator will not save Israel from a finding that it also possessed the requisite genocidal intent. And because of a fundamental feature of genocide, namely that the prohibitions on genocide and associated offences are jus cogens in nature, they are subject, therefore, to no exceptional qualification. They are absolute in nature, in times of war and peace, always and everywhere. Furthermore, the fact that the alleged acts may also be characterized as crimes other than genocide should not exclude the plausible inference of the existence of genocidal intent. As the UN Secretary General has stated, the prevention of genocide is intrinsically connected to preventing crimes against humanity and war crimes, as these crimes tend to occur concurrently in the same situation rather than as isolated events. Consequently, he said, initiatives aimed at preventing one of the crimes will in most circumstances also cover the others. And as also set out in the ILC articles on state responsibility, the wrongful act of genocide is generally made up of a series of acts which are themselves internationally wrongful. Madam President, honourable members of the Court, South Africa's claims thus concern in the first place its own obligations as a state party to the Genocide Convention to act to prevent and punish genocide. In the application, South Africa has stressed that it is acutely aware of its own obligation as a state party to the Convention to prevent genocide. Indeed, this Court has recognised the universal character both of the condemnation of genocide and of the cooperation required in order to liberate mankind from such an odious scourge. As the prohibition of genocide is assuredly a peremptory norm of international law, or jus cogens, it is crucial that states pursue their interest under the Convention in ensuring acts of genocide are prevented. Additionally, due to the special characteristics of the Genocide Convention, the respondent state owes this duty not only to the Palestinian people, but to all states parties to the Genocide Convention, including South Africa. This has been emphasised repeatedly by this Court and most recently in the Gambia case, where the Court held, and I quote, "All the states parties to the Genocide Convention have a common interest to ensure that acts of genocide are prevented, and that if they occur, their authors do not enjoy impunity. That common interest," said the Court, "implies that the obligations in question are owed by any state party to all the other states parties to the Convention." Similarly, the Court has reiterated that in such a convention, the contracting states do not have any interests of their own. They merely have, one and all, a common interest, namely the accomplishment of those high purposes which are the raison d'etre of the Convention. Accordingly, any state party to the Genocide Convention, and not only a specially affected state, may invoke the responsibility of another state party with a view to ascertaining the alleged failure to comply with its obligations, erga omnes partes, and to bring that failure to an end. That means that South Africa is asserting both a collective and an individual right. It is thus beyond doubt that South Africa is entitled to invoke the responsibility of Israel under the Genocide Convention. Through South Africa's interest in the common interest, and as a state party to the Genocide Convention itself, it is entitled to safeguard compliance with that instrument. As has been explained, the events unfolding in Gaza at the hands of the Israeli forces are frighteningly unprecedented. Yet what this Court is being asked to do in these proceedings, interdicting genocidal acts on an interim basis, is sadly by no means novel. In relation to genocide, the Court has indicated provisional measures in analogous circumstances to these in the Gambia case, where, as here, a state sought provisional measures on the basis of the erga omnes right that the Genocide Convention be complied with. Also, in respect of genocide, the Court did the same in the Bosnia and Ukraine cases. And most recently, this Court further accepted the erga omnes character of parties' rights in relation to the Torture Convention. So South Africa respectfully contends that in this case, the rights of the Palestinians in Gaza are no less worthy of this Court's considerable protective power under Article 41 to issue provisional measures. This Court cannot but find, as it did in the Gambia case, where this Court held that there is a correlation between the rights of members of groups protected under the Genocide Convention, the obligations incumbent on states parties thereto, and the right of any state party to seek compliance therewith by another state party. South Africa's request therefore complies with Article 41 of this Court statute and engages the power of this Court to preserve by such measures the rights which may subsequently be adjudged by it to belong to either party. South Africa requests this Court to discharge that critical protective power, and South Africa does so by virtue of its own clear right and solemn obligations held towards the international community as a whole. For the Court to indicate one or more provisional measures, there must also be a link between the rights, the protection of which is sought, and the provisional measure being requested. Such a link manifestly exists, we say, between the rights claimed by South Africa in its application and the provisional measures requested, which are directly linked to the rights which form the subject matter of the dispute. The provisional measures sought therefore ensure the protection of rights which might ultimately form the basis of a judgment in the exercise of the court's jurisdiction in due course. The rights at stake in these proceedings are certainly at least plausible, grounded in a possible interpretation of the Convention, and as the Convention imposes on parties the obligation to prevent and punish genocide under Article 1, and in doing so intends to protect groups and parts of groups from genocide. The Convention was designed to protect both states, parties, and human groups. When acts in breach of the Convention are perpetrated, it is the fundamental rights of people and the relevant group that are violated. Those fundamental rights of Palestinians in Gaza would be the subject of any judgment by this court on the merits. Madam President, members of the court, to find otherwise would not only be to treat Palestinians differently as less worthy of protection than others, it would also be for the court to unduly limit its own competence, to turn its back upon its extensive prior jurisprudence, and to close its eyes to the breach of the rights which lie at the heart of the Convention and which breaches are taking place in Gaza right now as I close. Madam President, I ask you now to call Ms. Negrali KC to the podium, who will address you on a risk of further genocidal acts, the risk of irreparable harm and urgency, and I thank you for your attention.
I thank Professor Duplessis, and I now invite Ms. Blinny Negrali to take the floor. You have the floor, Madam.
Madam President, members of the court, it is a great honor for me to appear before